This is your 1 minute warning. We'll be back in 1 minute. Okay, we are back. We've got 55 minutes left to cover quite a bit of information, so we're going to go quickly. That was really, for all of you that are out there listening, we gave Jordan a whole bunch of cases and things to get through, and he did a good job getting through all of it. So this was literally us a couple days ago saying, hey, Jordan, as an unintentional hazing ritual, why don't you go out there and take this entire section? So I think he did a good job with that. We're going to move on to a very related issue, and that is discipline. Going to start with a general overview. I'm going to go through that quickly because you all know that counting to 10 days is counting to 10 days, but we'll hit on some specifics there. Really what we want to focus on in this section, though, is the aspect of the regulations that talks about a child who is not yet identified or a child who is identified but has behavior issues that you haven't yet addressed. So with that, we'll get going. Generally speaking, the IDEA and the regulations make clear that school personnel may remove a child with a disability who violates your code of conduct for not more than 10 consecutive school days, and for additional removals not more than 10 consecutive school days for separate instances of misconduct, as long as those removals are not related, right, and actually constitute different types of behavior issues. So 10 consecutive days per offense, but what we always talk about, especially with these students that are increasingly violent, is the idea that if you have a pattern of removals, if you're removing for the same type of activity, the same type of misconduct, that's likely a change in placement. To be perfectly honest, when we have students, especially in the context of, well, yeah, we're not, yeah, he's new to the IEP, or we're not exactly sure if he has behavior issues that would, in addition to a current, but you have a student that's SLD right now, could that student also qualify as emotionally disturbed? We read this pretty conservatively, right? The only thing you're out is having 10 days to figure out what you're going to do. So we'll talk about that in a little bit. Real quickly, and we'll probably get some questions about this. If you have questions, text them in. I think the cases have started to move away from being aggressive in how you count to 10. So in other words, if you are sending a student out of school for some sort of suspension or expulsion that is not in the student's IEP or behavior intervention plan, for example, when the student acts out in a violent way, the student will go home for the remainder of that school day to regain emotional control. That becomes part, right, of the student's placement. What we're talking about is a disciplinary change in placement for actual out-of-school suspensions or expulsions. Those would always be counted, right? You almost always count in-school suspensions, bus suspensions, in any portion of a day where the child is removed from the placement. We have started to talk about in-school suspension slightly differently, in part because when you're talking about these violent behavior students, a lot of what you're doing, a lot of the stuff you have in your IEP is related to how that student acts in the classroom. So if we have an IEP or a BIP that says something like, this is how we're going to handle misbehaviors in the classroom, whether it's we're going to use some sort of reward system, if we're going to do some sort of red, yellow, green light system, whatever it might be, when you're talking about the services we owe to that child being in the classroom with his or her peers, putting the kid in in-school suspension means we can't use our red, yellow, and green light in the ISS room. So counting that as a change of placement, even if we're doing it somewhat conservatively. Cody's talked about transportation. The issue of a bus suspension can absolutely count. I think there are some circumstances, though, that hearing officers continue to say, yeah, that probably doesn't count. Things like after-school detention, even a lunch detention, but be very careful of those students where you have used lunch as an opportunity to socialize. Don't have a one-track mind of, well, if it's just a detention, or if it's just a detention during lunch, that doesn't count. It still could. So, in theory, the IDEA and the Code of Federal Regulations talk about discipline in a, oh, of course you can do it, right? There's just these few things you have to do. But in reality, it is actually quite difficult, it's highly technical, and we'll talk through some of those technicalities. So, you're supposed to consider unique circumstances on a case-by-case basis when you're determining whether a change of placement, consistent with the other requirements of the IDEA, is appropriate for a child with a disability who violates a code of conduct. More often than not, when you call us and say, Bobby, I have a student that punched another one in the face, one of the questions, as Karen mentioned, does the student have an IEP? No. Should the student have an IEP? Have we had instances like this in the past? No, Bobby, the kid's just SLD. Well, that doesn't answer the question, right? One of the things that you can get under the Nebraska Student Discipline Act is an expulsion. If you have a student who's acting out and is only, for example, damaging property, that expulsion is only going to get you through the end of the semester. If you look at it from a placement perspective, if we don't do the manifestation determination route to discipline, we've got authority to change the placement. One of the big things that is a source of confusion out there is, I hear what you're saying, KSB. We should look at this as a placement question, but we're only going to do that if we decide it's a manifestation, because I want to kick him out if it's not a manifestation. There is a difference between starting down the placement road and doing manifestation and determining it is manifestation. If we start down the manifestation road and it is manifestation, you cannot, as a team, change the placement without agreement of the parent. Do not confuse these things. So as the administrator, if you're a principal or superintendent sitting out there thinking, all right, I've heard you guys talk about this enough. We get it. At 10 days, we got to figure out if we should change the kid's placement. That is not what we're saying. Don't hear us say that, right? Because we are down the manifestation road at that point. If we decide it's a manifestation, we can't change the placement without parent consent. What this regulation asks you to do is think about whether from the get-go, you should look at this as a possible change of placement from an educational perspective. So what constitutes major discipline? Removals for more than 10 days, expulsion. You can have removal for those 45 days for specific circumstances, for drugs, for weapons, for serious bodily injury. The MDR must be conducted by the LEA, the parent, and relevant members of the child's team. So when we're going through the manifestation determination review process, make sure you got the right folks there. So what do we review? The team has to review, number one, all of the relevant information in the kid's file, including the kid's IEP and teacher observations of the child, and any relevant information provided by the parent. So we should be saying to the parent, have you seen these sort of behaviors? And as Karen pointed out, they say, well, this never happens at home. We should have good notes of that, and we should consider whether we actually believe them, right? Or if there's some more additional data that we should gather. So the questions to ask, we have decided that there's student misconduct. We're in a manifestation determination review. Was the misbehavior caused by the student's disability? This one right here is typically where most teams stop. I think we should do a better job of really focusing on the second two questions. Was the conduct in question caused by, or did it have a direct and substantial relationship to the child's disability? This does not say we know the kid's SLD, so the only thing that we're thinking about is whether it's related to SLD. As we'll talk about in a second, the regulations apply to the child's disabilities, even if we have not identified that child is also suffering from an emotional disturbance. Got to keep that stuff in mind because that's part of what the team has to consider. When we talk about the letter that OSEP released recently, well, Bobby, if we only have an SLD verification, but we think the child may be ED, what are we using to decide if it's, for example, caused by an emotional disturbance if we don't yet have that data? The short answer out there is they say use what you got, but you have to consider that. You can't leave that question off the table just because we haven't gone fully down the ED path yet. Or as Karen talked about from the beginning, we're waiting to have that long period of time. Last thing, was the misconduct a direct result of the district's failure to implement the IEP? This is one, again, that we should make sure that we're asking. It wasn't because he's SLD, doesn't answer all of the questions, right? Did we fail to implement the IEP in some way? So this is actually a charter school case, a student diagnosed with disruptive mood dysregulation disorder. An essential feature is chronic, severe, and persistent irritability and low frustration tolerance. Student involved in a physical altercation with a peer, and this is where this case gets really interesting. The student tried to take a peer's shoes after she refused to consent to being photographed. So clearly we have some social skills types of things here that should be addressed, but basically kid says, I want to take a picture of you. No. So the student that's on this IEP steals her shoes. They call a manifestation determination review together. They have the student in there. The student describes the incident, I was just horsing around, it was just horseplay. What's interesting is we actually have a school psych and we have an LMHP from outside the school that comes in and provides an opinion that, this kid told me it was just horseplay. Obviously, even a student with an emotional disturbance or some sort of disruptive mood disorder can still engage in horseplay. We got to make sure not everything is tied to the disruptive mood disorder. Well, so the team decides that this is not a manifestation because the kid and the kid's outside psychologist said, this is not a product of his anger. This didn't involve his aggression. So the school says, because it's not a manifestation, we're going to expel him. This is where you have to make sure, if you are a principal sitting in that MDR, look at the student discipline code section you're going to be using for your discipline and make sure it doesn't line up exactly with the things that we have listed as consequences of the student's misbehavior or as products of the student's perpetual misbehavior. So in this case, they're sitting there and the principal says, we're going to expel him for attempted use of force, coercion, intimidation, or threat of violence, which happen to be things the school had in its documentation as impacts of his disability, right? So the hearing officer's looking at this like, I see the student discipline letter you have, and I see the documentation you have for this kid, and they say the same stuff, but you're telling me this isn't a manifestation. That's one of the key takeaways here, right? Make sure that we are mindful of you're in that MDR. Of course, you haven't decided whether you're going to expel yet, right? Wink and a nod. As we try to line up the timelines for this stuff, this is one of the things that the hearing officer notes. The hearing officer says, I literally don't care what the student said, and I don't care what the student's outside expert said, right? The student's misbehavior based on the documentation in the school and the school's characterization of that student's misbehavior are consistent. So it is a manifestation, even if the student says, I wasn't angry, it was just horseplay, and even if the kid's outside psych supports what the team wants to do here, which is expel. This is a case, the Ilya Cole case, a 17-year-old student with an emotional disturbance. He again has that long history of violent disruptive behavior. This is a serious incident where the kid repeatedly punches a classmate, causing the classmate to have a seizure, significant bruising, memory loss, and a substantial concussion, right? This is the sort of case where we're looking at it thinking, okay, if those 45-day exclusions to that interim alternative setting mean anything, clearly this is causing a serious bodily injury. So they conduct a manifestation determination reviews. This is clearly a manifestation of the student's emotional disturbance, but remember, because it falls into one of those three categories of guns, drugs, or a serious bodily injury, we can still remove the student for 45 days to this interim alternative education setting. The problem that you have here is that the 45 days expired before the school could get in front of a hearing officer to decide if the district's proposed change in placement after those 45 days was appropriate. So the parents say, once we hit day 46, my kid gets to come back, and I don't care how big of a threat that you think they are, because the stay put provision requires a student to return back to his or her previous placement at that point. The school said, that's clearly an inappropriate placement. If we bring the kid back, the next kid that he punches in the face is going to sue us because we were negligent. Good argument. The problem that you have here is the school decides, well, we're going to err on the side of not getting sued because we don't want him to punch another kid versus you not suing us because we inappropriately changed the placement. The hearing officer in this case, I don't care what your concerns were, school, the IDEA is clear. That stay put requirement entitles the student to come back, which is why in this case, I would not have looked at it from the discipline context.
Yes.
I would have said, let's change the kid placement from the start so that we don't have to deal with not only our Student Discipline Act requirements and how they don't line up with the IAES requirements, but also because we got to bring the kid back after those 45 days or after the semester of expulsion. The kid was presumptively entitled to have the student stay put while the school sought to allow a change in placement. So basically what happened is at the end of the 45 days, the school says, we want to change the placement. The parent says, I disagree with that change in placement because it's going to be homebound. I don't want to be home all day with my super violent kid. So starting day 46 and until we can get in front of a hearing officer, the school has to put the kid back in school. So the parents get the super compensatory education. Okay, so that's the general overview about the discipline requirements. This is one that we literally get every week. Bobby, we had a significant fight in the lunchroom. One kid beat the hell out of another one. Okay, what do you want to do? Well, this student we already sent home. This student's going to be given a 10-day out-of-school suspension. He fought back, but he didn't start the fight. What about the kid that started the fight? We want to expel him. Okay, sounds good. Does he have an IEP? Nope, no problem at all. 32 on the ACT. Should he have an IEP? Do we have an emotional disturbance? Is there something else here? Well, I mean, I guess he did mention that, he's felt depressed before. We had these, I know he's seen a counselor outside of school for a while. I have no idea how that stuff's going. The parents have exchanged some emails with me and with the teachers about behavior issues. And yeah, I've even got one email here that the outside counselor said it may be a good idea if we think about whether the kid needs some additional support in the classroom. All that stuff that you are saying right there, which in your opinion is like, this is proving that we have not yet put the kid on an IEP, is actually making it more likely that you have to treat the kid as though the kid's on an IEP. So how does this work? The Rule 51, if you have not looked at this, please write this down, review it with your staff, anybody that's on an IEP team. Look at subsection 16.06 of Rule 51. There's an almost identical federal regulation, and what it says is, if the school has prior knowledge that a child who is engaged in a disciplinary code of conduct violation situation, if that school has prior knowledge that the kid may qualify under Rule 51 or under the federal regs as a student with a disability under the IDEA, you have to give them all of the rights in Rule 51. And we'll talk about how that works in a case here in a second. So that begs the question, this kid that knocked out his classmate in the lunchroom, Bobby, we've got some data. We've got a student discipline file. We've sent this kid home before for getting in other skirmishes, but it's not like we've had our psych in front of the kid yet. You're telling me that within 10 days, we've got to decide if this is a manifestation of a kid that we haven't gathered any data on? That is exactly the question that Nathan, that's why we have letters of Nathan, asked OSEP. So once it's been established that the child is a child who the local education agency is deemed to know could have had a disability, right? So we have one of the triggering factors here that says, yeah, the school had prior knowledge, even if he's not yet verified. Can we, the school, at least wait to do manifestation until we can do an initial evaluation? We should get the psych in front of this kid, otherwise our answer is going to be pretty much based on nothing, right? So shouldn't we be able to postpone that manifestation until we can evaluate? OSEP, no. The child, by law, if we suspect that they have a disability or if we've got prior knowledge, for example, a parent request to evaluate, teacher concerns, that child is entitled to a manifestation determination review just like a child that's already on an IEP. That does not include an exception to allow you more time to conduct the MDR. You must conduct a manifestation even for a kid who's not yet verified if we have prior knowledge within 10 days, just like you would for a kid who's on an IEP. While the school may choose or find it necessary to do expedited evaluations, we cannot delay the manifestation determination review even by a day to allow those to occur. Second question. So if we have no information about this kid, because actually he just moved in, he's from out of state, they didn't have him on an IEP, now we know clearly the kid has some sort of issues that probably are going to qualify him, though he's not on an IEP yet. If we can't postpone it, how should we conduct the MDR? What should we look at? If number one, we have little to no information, and number two, the purpose is to determine whether the behavior is a result of a disability that we haven't even yet been able to evaluate and assess. OSEP, the team must consider all relevant information. In other words, good luck to you. Consider what you have, do the best you can, right? There's no IEP, so there can't be a failure to implement. So really when we're asking whether a student who's not yet on an IEP, whether that action or misconduct is a manifestation, we can leave off one of those questions, right? We don't have an IEP, so we've not failed to implement it, but we still ask the other ones. Is it a manifestation of the student's disability? Is it directly and substantially related to the disability? Based upon that review, your group in your MDR should determine whether the conduct in question was caused by or had that direct and substantial relationship to the child's suspected disability. Well, Bobby, aren't we predetermining if we walk in and say, oh yeah, this kid's totally disabled? The answer from OSEP is no, not really, right? Because the MDR is a standalone requirement. To the extent that that's awkward, we get it, but you have to consider what disability you suspect when conducting the MDR, even if the kid doesn't have an IDEA. And there's nothing in the IDEA that would prevent the LEA from conducting an MDR, so long as it's conducted within 10 days of the decision to change a student's placement due to a violation of the code of conduct. So does posting the procedural safeguard notice on the LEA's website and providing a link in the suspension notice letters to parents constitute sufficient notice to the parents in these cases of kids who are not yet identified? And OSET says in this case, under the law, on the date which the decision is made, we, the school, have to notify the parents of the decision and all their procedural safeguards. This is a step you are leaving off, right? We have to give parents a copy of their procedural safeguards on the date the decision is made. We're going to expel the kid, even though we have prior knowledge and take our chances with the MDR. We don't get to wait until our 10 days are up to give the parents their procedural safeguards. We give them those procedural safeguards that day, which is fundamentally inconsistent with the timing of the student discipline, right? So be thinking about this stuff as it's ongoing. That's why we continue to harass you with the questions of, well, should it be? Should the student be on an IEP? Posting on your website is permissible, but you must still provide a paper copy to parents on the day that it happens. So yes, if they go pull it off the website and then you hand them another copy, they just have two, but we can't leave off the second step. Good.
I was just gonna say real quick, I do hear parents sometimes say, Jesus God Almighty, you're giving me another copy of this stupid piece of paper? How many of these do you want to? If parents are saying that, you're doing it right, right? If they're saying, why are you giving this to me again? You got it.
Yeah. So this is a really interesting case, and if you look, it was the day before Halloween. What happens here is, and the outcome of this is interesting because, of course, the news story says, mom of the teen expelled over a fight in school that was caught on video files a complaint against the school. What I read, my lawyer brain said, oh, she sued him. That's not what happened. So you have a student who is allegedly suffering from all sorts of depression, anxiety. Mom says, because of course when it hits the news, it's the parents' version of events, right?
Always.
Mom says, I've been hounding this school for 4 years to evaluate my kid. They've done nothing. They've given him no services. They've done nothing to help him. Now the school has not yet given its side of this case, right? But understand, this is how it is portrayed to members of your public. There is a significant fight that breaks out in the lunchroom where a girl walks up to this male student, shoves him. The male student shoves him, or shoves the girl back. She takes a swing at him and misses. He cold cocks her and knocks her out, right? So what you have in this, and of course, this is caught on video in the middle of the lunchroom. So the school says, we are going to expel the kid, no questions asked. Well, mom consults with a lawyer who says, now hold on a second. Sure, we could sue the school if we think that they're discriminating against your kid. But here's what they do instead. The attorney says that schools have to follow federal law that requires them to identify and evaluate children with disabilities. The school had a choice. You can either help the student, as mom's been asking you for years, or you can punish him. The parent's lawyer says in this case, the school could have prevented the fight by addressing the bullying and the alleged racism and all the special needs that mom's been talking about for 4 years. Everything she asked for, they always said no. And now they're like, okay, he got in a fight, so we're going to expel him. So when the lawyer decides what to do in this case, he doesn't file a lawsuit. He files a complaint with the State Department of Education saying that the school has denied this child under their child find obligation and their obligation to provide special education services. So this lawyer is saying, I think I've got probably good claims under both, right? If I talk to this lawyer, my assumption is this lawyer would say, we could have filed, I think, a lawsuit because the school functionally discriminated against the kid by outright failing to even consider the disability. But this could also be a faith issue. So if you remember the Fry case, do you have to exhaust your administrative remedies or not? I think this lawyer looks at this and says, I've got an open and shut child find case here. So I'm going to start with faith because that's going to allow, for example, the school to have to force the kid to remain in the building, right? We get stay put, we get all that stuff. The reason that this attorney can file this claim with the State Department of Ed is because of the equivalent of our subsection 16.06 in Rule 51. Because this is a child who the school should have known potentially had a disability that would qualify under Rule 51. So the White River Valley case is a string of behavior issues in late 2016. Parents of a student diagnosed with ADHD and anxiety request an evaluation. They specifically request IDEA services. There's no documentation from the school that they ever took steps to evaluate the kid. And so we have in November, though, the interesting fact in this case, in November of 2016, the teacher starts to email with the parent. I saw these 17 behaviors this week. And the parents at this point are basing their requests for an evaluation on emails coming from the teacher, right? So this is a problem for the school. One of the ways that you can have prior knowledge under subsection 16.06 is if parents have communicated concerns in writing to your teacher. So if you've got a poor little first-year teacher that has significant behavior problems with the kid in class that's emailing with mom and dad, that teacher, he or she probably has no idea that they are setting you up squarely for both a child fine violation if they don't immediately send it to you. They're trying not to be the needy first-year teacher, but they've actually engaged in an act of legal significance under the IDEA, which will bind the school district, probably forever, by exchanging those emails with parents about behavior issues. So once those behavior issues persist, in late 2017, the student is a violation, so that next year, the student is in another serious altercation, and the district at that point says, we're going to impose a suspension of more than 10 days, we're going to expel the kid. The parent says that the 10-day suspension violates the IDEA because they did not give our child manifestation. The school says your child was not yet identified as a student with a disability, you're not entitled to it, ruled for the parents. The suspension was inappropriate without following the IDEA discipline process. Under this subsection, just like our Rule 51, for disciplinary purposes, the school has knowledge that the student is a child with a disability if the parent requested an evaluation prior to the misconduct. In this case, they hit two of the prior knowledge prongs. A teacher has received input in writing from the parent that they believe the kid may have a disability, and the family has requested an evaluation. If a family says, would you please identify our student, right? There are only a couple of appropriate responses. No, we're not going to evaluate your student. Here's a prior written notice and a copy of your procedural safeguards. Or yes, ma'am, yes, sir, here is a consent to evaluate, right? Well, this could be an emotional disturbance, so why don't we just kick this can down the road for a couple months to figure out if we have a long period of time, is unacceptable. If you believe you need more data, then you should say we're not going to evaluate now because we are working through our MTSS process. But if parents request an evaluation, we cannot say no, never possible because of the MTSS process, right? A parent request is the trump card. That is also true in circumstances where now you want to discipline that student. So if it is not a manifestation of the child's disability, whether or not they've been identified, right, the child can be punished like a regular education student, sort of. The sort of is because if the parents after that point, you've got a family that has no idea what this whole IDEA process is about. You hit them with a flurry of due process and paperwork, and all of a sudden they're like, oh yeah, maybe we should ask for this, right? If they do, you have to do an expedited evaluation. If it is a manifestation of the disability of a child who is on an IEP or who is not on an IEP but we have prior knowledge, we must conduct an FBA, implement the BIP, or review an existing BIP. We cannot punish the student. We must return the child to the prior placement unless the parents agree. Hold on a second, Bobby. Kid we don't even have on an IEP knocks out one of his classmates. We get to this point and we say, yeah, the kid probably does have an emotional disturbance. You should see some of these emails the parents have been sending the special ed teacher and the teacher. We kind of got our wires crossed because I sent home the discipline paperwork before I talked to them. Yes, absolutely. You cannot, if you get your manifestation determination team together, you cannot then at that point, if it is a manifestation, march down the change of placement path. That's why from the beginning, you have to be answering that question. You must conduct, if the misconduct is not a manifestation, you still have to follow the Student Discipline Act, put an IAES in place, determined by the team. What if it's a kid who's not yet, right, verified? Hurry up and get that stuff done. That's a short answer in the law. If it is a manifestation, again, the team must conduct the FBA, put a BIP in place or modify the BIP, and then return the child to their place. That's just the regulations saying the same thing. Last case here, the North Thurston case, a 16-year-old on an IEP with an emotional behavior disturbance threatens to shoot a peer. Criminal consequence, this is interesting, right? So we have these school threat cases that come up all the time. Student says to another, I'm going to shoot you in the head, right? The school, appropriately in that case, notifies law enforcement. We'd have no choice in Nebraska if we believe we've seen a terroristic threat. That could be both child abuse. That could also be a required criminal report under the Student Discipline Act. Police come in, they charge the child. Child goes in front of a judge who says the only way we're going to let you out of this juvenile detention center is if you have no contact with the other student. Now, of course, judges enter these orders all the time in custody cases, for example, where dad's abusive, mom and child go get a protection order that says dad can't have any contact, or two kids get in a fight and one family gets a protection order. The school, in general, is not governed by that order, right? We are not part of that court process. But what do we get if you have a kid who, yeah, we totally agree. We don't want this kid in school, but we know we got all this manifestation junk we'd have to deal with, so what do we do? The school in this case says, well, here's the deal. We're going to expel him. They eventually modify it to a long-term suspension, which apparently in Washington is like half of a year anyway. But the manifestation within 10 days of removal occurs. The manifestation determination team concludes that the misconduct is clearly caused by the disability. It was actually part of the school's failure to implement the student's IEP because he was missing some services. So the school says, hey, good news. You can come back to the school district, but you have to go to a different high school, right? So this becomes a question of whether we've actually changed the student's placement. They proposed 2 other high schools in the district. Now, this doesn't work, right? Bill, if you're there in West Point, we didn't have another high school that we can send the kid to. But in this particular case, they actually had 2 other high schools. They say to the parent, we'll give you a choice. You can go, you're in high school A, you can go to high school B, high school C, or alternative program D, and we can provide all of the services in the kid's IEP. The parents in this case says, nope, I'm not going to do that. That is a change of placement. And the ALJ in this case says changing high school buildings is not a change of placement. The student can receive the same program in all of those schools. So this works great, right? If you can change the kid to a different high school. But if we don't have this obligation and saying there's one high school and you can't be here, even if a judge is the one saying it, is a change of placement that a judge is forced to do, right? We have to deal with that through the IEP process. Okay, questions? None.
No questions yet.